On to Alison Goldthorp, who's back by popular acclaim to give us an insolvency case law update.
Good morning, everybody. I will be quick because I know I'm the graveyard slot, so I'll try and rattle through this, but I think it's quite topical. Last week we had the administration of Phones for You, which is the first big retail administration for quite some time, and I think it's an opportune moment for us to kind of recall what happened when there was a lot of administrations. And I think those of us who work in insolvency and restructuring really predict that there will be another wave of insolvencies that will affect all of us as soon as interest rates start to rise and as we come out of recession. It's always the case that as we come out of recession, there's more litigation and there's more insolvencies. So there are things that you need to kind of bear in mind when you're running your day-to-day businesses. I want to talk about four things that have happened in the insolvency world since I last spoke at the update here. They're generally not cases this time, but they're important things to think about when you're going about your day-to-day business with your suppliers, and things that will affect decisions that they take and that the banks are taking in terms of enforcement, which affect all of us. Just touching briefly first on the Tomlinson Report, you'll have read about that in the press. Vince Cable, as the in charge of the DBIS, Business Information and Board of Trade, as it was, he commissioned a report into the RBS restructuring team by a chap called Tomlinson, which was rather bizarre given that Tomlinson had actually had a failed business and therefore wasn't really RBS's biggest fan to start off with. That all didn't really come out until the report came out, and it criticised the way in which that team had operated, even though it had actually successfully saved a lot of businesses. That's caused a lot of heat in our restructuring world, and as a result, I think people are even less keen to appoint administrators at banks than they were before. And when I spoke last time, I explained that actually a lot of banks were sitting on their hands, not wanting to actually put customers into administration because of the heat that had been on the banks for the last few years. What we're seeing in the market now is a lot more formal appointments actually starting to happen because people can't pay their debts as and when they fall due. They're being wound up by HMRC. There's a general pressure on cash flow, and that's leading to more insolvencies. So it's something to be aware of. Make sure that you're tracking whether your key suppliers are paying you or paying their third-party suppliers, and continuing to trade, and make sure you've got contingency plans in place if you're very reliant on one particular supplier that you think could be in financial difficulties. RBS's work has been reviewed by Clifford Chance, and they were passed with flying colours, but it has meant that there's a continuing scrutiny of decisions of banks in terms of enforcement. As you'll have also seen, a lot of banks have actually sold their portfolios of loans recently, so we've got a lot of new entrants into the market, and that again is probably going to lead to more enforcement. A lot of funds have bought portfolios from Lloyds, from the Irish banks, and from other banks, and we don't really know what steps they'll take in terms of enforcement. Some of them have bought at a very low rate, and therefore they may well enforce and appoint administrators. Others will hold and try to make a better turn on their investment. So we're in quite a period of uncertainty in insolvency and restructuring, and I think that means that everybody needs to be very aware in terms of reacting to any market information you have about a key supplier or contracting party that may have insolvency difficulties. The swaps review has also led to a lot of delay in terms of enforcement against individual customers for banks, whilst they had to go through the statutory processes to investigate the swaps that were lent or advanced to those particular clients. Again, we're coming to the end of that and the unwinding of that, and I think that'll lead to more enforcement. So generally everything points to quite a busy year ahead in terms of administration appointments. Pre-packs. Just wanted to have a quick revision on what a pre-pack was, because I think we'll see a lot more of those. Phones for You was not a pre-pack. Phones for You was a shutdown, which resulted, we're told, by the company being concerned about losing two major contracts. Very often, trading companies enter into a pre-pack, and a pre-pack is a pre-packaged sale of the business, which is negotiated prior to the appointment of the administrator. But as soon as the administrator is appointed, the first thing he does is sign the sale contract and the business is sold. And the reason for that is to try to make sure that the business's value is tainted as least as possible by the insolvency process. So this is common with law firms, with any sort of trading business where employees will walk out the door as soon as the business goes into an insolvency process. It's very common. It's also much criticised, and the government is very concerned about it. We've just had Theresa Graham reviewing pre-packs, and the Graham report on pre-packs is available online, and there are possible legislative changes that we might have later in the year to pre-packs. The suggestion now isn't to abolish them, because I think it's accepted that they are a very good way of saving jobs, and the research that has been commissioned on the subject shows that actually employees do very well out of pre-packs. The difficulty with them is transparency, and people like landlords not knowing that they're happening and being concerned afterwards that the right deal has been done. The particular type of pre-pack that is criticised is often where it's a sale back to the directors and everybody thinks it's sort of an inside job. And that's the area that Theresa Graham was critical of in her report. She's suggesting that there should be some sort of viability statement from the buyer that the company will continue for at least 12 months. There's a possible requirement to have the pre-pack approved by an independent pre-pack pool of experienced people, and possibly a requirement for a professional valuation. But where that goes in terms of actually what's enacted, we'll have to see. That the bill will come up in the autumn, and it may be included in the Small Business, Enterprise and Employment Bill as a change to the law at the moment. There are also a lot of things to be aware of if you haven't done any insolvency work for a while that have changed in the government's red tape challenge. The bankruptcy process has been speeded up considerably, and the county courts have got a lot more powers than they had. So I think check or give us a call if you're starting off on that sort of process. There are quite a few changes. There are also proposed changes to reporting to creditors. A lot more creditors' reports appear online and on websites, and you won't be sent them in the post. So if you want to keep on top of those types of reports, you need to be looking online to find out what's going on in any particular case. There's a possibility that the power to bring wrongful and fraudulent trading claims may be extended to administrators, not just liquidators. And we've got new insolvency rules coming up in 2015, so quite a lot of change here. So happy to discuss that with anybody who's wanting more detail. My last slide, you'll be pleased to know, we heard earlier from Ralph about the Jackson reforms as they affect commercial litigation. They also affect insolvency, but at the moment we're caught by an exemption that means that we don't actually have to apply them in full at the moment. R3, which is the Association of Business Recovery Professionals, have been lobbying for that exemption to continue. We were hoping that it should continue into the end of next year. At the moment, the government is saying they will abolish it for us in April, so we'll become party to the whole of the Jackson reforms and the inability to recover success fees and ATE premiums. Again, adding on to Ralph's comments, it's quite a complex area, not something for the last 5 minutes of a seminar, but happy to discuss separately if you're wanting to know more about that. Probably is going to mean that there'll be a rush of claims by insolvency practitioners in the run-up to April 2015 to make sure that they're covered by the existing exemption. And there's a big policy decision about whether that's the right thing for the country, given that actually fewer and fewer directors are being disqualified by the Insolvency Service because they haven't got many people to pursue disqualification proceedings, and whether, therefore, as a matter of public policy, we should have more claims by liquidators against naughty directors who take money from companies. But that's for another day. So thank you very much for listening to me. Sorry that I was the last slide. And over to Clarissa to close.
Well, bang on time, 10:10. We have some time for questions. If anyone wants to ask anything, might even have a microphone. Well, everyone's going to stand outside for a little while for coffee, so if you have any questions you don't want to ask in public, because you want to keep them confidential, then we'll be around outside. A big thank you to all the speakers for really varied, interesting, topical talks today, keeping us all up to date. The next talk is 30th of October. It's a fraud update. Please do fill in the feedback forms, and in particular, any topics that you want us to talk about, something that's kind of interesting you or worrying you, we can find someone who can talk to you about it. If you've heard anything today that you would like your colleagues to hear, we can arrange for talks directly at your for your colleagues at your businesses, and we're really happy to do that. There's CPD forms outside. I know it's September, coming up to CPD year end, so do sign it. And coffee outside, so a big thank you to the speakers and to you.